evening. So today's session is all about IP infringement, a new dimension that we are going to look at in terms of the intellectual property rights. So far we looked at the life cycle in terms of its registration. We saw how it is commercialized, and today's session is specific to IP litigations. And of course, we have Ashok with us, and he is an expert on this. And I had done a lot of IP litigations. In fact, today also he was representing a trademark infringement suit. That's the discussion we had just a while before. And so over to you, Ashok, and please go ahead with the session.
Thank you so much, ma'am. So let's begin then. The entire focus or the reason why anyone invests in creating IP, protecting IP is only for one reason: the ability to go after people who are using the IP without due permissions. So in the last module, for example, we discussed how do we monetize IP using contracts. So the whole reason why you can even monetize IP is because of the fact that there is in fact a right for you to stop somebody from using it. So essentially the law looks at giving you a kind of a monopoly. It's a lawful monopoly, and therefore there is a commercial advantage that you gain as a result of being creative and being able to bring IP into existence. And if there is no mechanisms by which you can stop somebody from misusing or using IP without your permission, there is no commercial value, right? Because today, when we talk about what is the meaning of ownership, ownership by definition includes the right to exclude. So the house is valuable because you have the right to decide who gets in and out. That's the ownership right, right? So there's a similar concept that's applicable to IP as well. So what we'll be looking at today is a broad overview of IP infringement. Now, IP infringement as a term is an umbrella term. It covers a vast variety of intellectual property rights. It could be something that is very well understood and defined in law, like trademarks or patents. It could be something that is yet to be recognized in the law, but there's potential to recognize it. One of the recent evolutions in terms of a subset of IP rights was publicity rights. So IP as an umbrella term is very vast. It can include patents, copyright, trademarks, know-how, trade secrets. It could include a lot more than that, like, for example, publicity rights. So we will be looking at trying to understand the underlying concepts of IP infringement and then figuring out what's the best way to enforce or litigate against IP infringement, right? Now, as part of it, we'll be looking at three principal things. One is, how do we precisely identify the IP? What are the kind of procedural compliances when it comes to IP infringement litigations and enforcement actions? And the nature of the evidence that one has to look at. While we look at these things, we're going to take a very practical approach. So we are not going to go provision by provision to understand what is infringement of trademark, what is infringement of patents, because in the scheme of 1 hour, we have certain limitations in terms of being able to cover the entire gambit. But we will be looking at the basic do's and don'ts when it comes to IP infringement. Okay. Now, one of the challenges of IP infringement is to first be able to identify the IP itself. The challenge is made worse by two things. One is there's a statutory framework that will define and govern the definition or the recognition of IPR. One of the best examples I can think of are patents. Patents exist because there is a law that defines what is a patent and what are the rights associated with the patent holder and what is the definition of when is a patent infringed and what are the remedies available. But there are also common law frameworks that will govern IP identification. So a lot of times you could have IP that is not at all recognized in a statute, nevertheless enforceable in the realm of English common law. If any of you have ever dealt with, for example, passing off. So when you have an unregistered trademark and you need to enforce that unregistered trademark because somebody else is copying your mark without really taking permission from you and therefore causing confusion in the eyes of the consumer as to who the source of the goods are. It is not a case where Indian law comes back and says that, look, you don't have registration for your trademark, so therefore don't expect any kind of recourse. On the contrary, Indian law says under specified circumstances, even unregistered or statutorily unrecognized IP can also be enforced. And the two examples I can think of are one, goodwill or reputation in the form of passing off and defamation. Two, trade secrets which are not subject matter of confidentiality agreements. Right? So when we have to think about litigating IP, the first step is to figure out what IP are we sitting on. And it is always a very bad idea to say, okay, because we have a statutorily recognized right, we will simply not look at any other form of protection whatsoever, right? So that is something that the law says is not permissible. Just give me 1 second. There seems to be some interference. Sorry about that. So it's very important that when we start identifying IP, we take a very holistic approach, because one of the core strategies of enforcement is that if you have more than one ammunition available to you, you fire all of them. So if we are dealing with a registered trademark, we will not only looking at we'll not only look at initiating an infringement action, but we are also then looking at a common law action for passing off. So we do both, even though the law gives us a better right in the form of infringement, which is easier to establish. We never take our chances with just one approach, right? So when you go about identifying a potential infringement action and how to litigate or enforce against it, always remember the first step is to be very clear about what IP we are sitting on, which can be potentially enforced. And that IP can either be in the form of statutory frameworks or it could be in the form of common law. Now, the other thing to also remember is because there is something called as privacy, which allows us to own the usufructs or the fruits of our labor and effort. What is not IP today may become IP tomorrow. And one of the best examples in the recent times has been publicity rights. If any of you have heard about the famous litigation involving Anil Kapoor, who managed to go to the court of law and acquire an order which said that some of his trademark ways of uttering dialogues, like say, I think there was this one word called jackass, and he's managed to get a IP on top of that, right, in the form of publicity rights. So tomorrow, if somebody has to imitate Anil Kapoor, there will be some difficulties, or they might have to go and procure some licenses and permissions, right? So there was something called as performance rights in copyright already. But publicity right goes one step further beyond that, right? Which is to say that, merely because something has become synonymous with you and there is fame attached to it, there's a certain right of publicity that you get to regulate. So whenever you're sitting down and identifying IP, it's important to also recognize that IP that is not yet in existence can still be litigated, provided you are able to create the right framework of jurisprudence around it. So we can't just go tomorrow and say that, a particular thing is IP simply because we think it is IP. It's important we build the right kind of theoretical framework around it. If we are able to do that, the courts are quite likely to recognize certain rights that don't exist today. But if sufficiently justified, they could recognize that as IP tomorrow. Right? Any questions so far? Now, when it comes to infringement, each form of IP has different versions of infringement available. Right? So if you look at broad categories of infringement, somebody owns IP, somebody else is using that IP without their permission, that is usually covered as infringement. Okay. Now, what do we say when we say use? Use is, for example, being able to reproduce IP without permission. Use is, for example, being able to manufacture products protected by a trademark by affixing the trademark without permission. Selling of those IP protected products without permission. All these are garden variety examples of IP infringement. But each IP has very unique elements of infringement associated with it. To give you an example, under the provisions of the Trademarks Act, specifically 29(8), if I use the trademark of the plaintiff in a manner that takes unfair advantage of the trademark or results in the disparagement of the trademark or the brand, then that is also recognized as a form of trademark infringement. Now, this you would have heard in common law as malicious falsehood, product disparagement, trademark disparagement. All of this is also given the color of infringement by virtue of 29(8) of the Trademarks Act. But will, for example, adversely affecting a patent's reputation result in patent infringement proceedings? Probably not. Okay. So it's always important to remember that while certain principles are common to across all IP, there will be very unique aspects of infringement associated with each form of IP. And to be able to recognize that is a product of two things. One, careful study of the facts in front of you, but also very clear research into what the IP is and what the forms of infringement are. Like I said, sometimes in your mind, we would have assumed that it is only selling or reproducing of IP that is infringement. But as we discussed in the case of trademark disparagement or product disparagement, you could have a situation where there is infringement which is outside of the scope of merely reproducing or selling. Like, for example, defaming or disparaging a trademark. Right? Now, when it comes to IP infringement, the other thing to also remember, especially in the context of what remedies are eventually likely to be available or how or where to enforce the IP, is it's important that we also recognize that there are statutory frameworks for infringement when it comes to infringement at the hands of a stranger. Like, for example, 29(8). If somebody were to create an advertisement disparaging or denigrating a trademark, right, making fun of the competitor beyond a certain threshold, which is authorized by Article 19 of the Constitution, then there are statutory frameworks and common law frameworks. So best example, trademark infringement, passing off, copyright infringement, design infringement, patent infringement. But a lot of times infringement could also be at the hands of a contracting party. Now let's take an example. I enter into a contract for the purposes of licensing the use of my trademark for a franchise. Kentucky Fried Chicken, McDonald's, Adidas, a whole bunch of these are very good example of franchises. Now let's assume that my agreement is being breached by the franchisee. Right? He's not giving me adequate amount of consideration. He is not following my best business practices. The trade design in the outlet is very different from the trade design of my other outlets. The chairs look different. The color layouts looks different. The menus look different. So there could be a lot of violations of the franchise agreement or the license agreement. Now, if I terminate the license, if he continues to use the trademark, then there is perhaps a breach of a contractual obligation for him to cease using the trademark because the agreement has come to an end. At the same time, there is also infringement of IP under the law itself. So there's a contractual violation coupled with a violation of a particular statutory right or a common law right. Now, in these circumstances, you have a dual cause of action. You have both a cause of action as IP infringement as well as a breach of contract. Now, one of the best agreement. Confidential with contractual obligations around confidential information. How the recipient will not be allowed to use a trademark, trade secret. How they will not be allowed to. Sorry, one second. Am I audible? Is everybody able to listen to me?
Sir, audible, sir. Sir, bit disturbance from your side.
Okay.
Issues.
Okay. One second. Just give me 1 second. I'm going to try and. Yes. So we were talking about the statutory frameworks and common law frameworks and the contractual frameworks. So especially when it comes to confidential information or trade secrets, you have a dual cause of action because one, the contract will anyway stipulate that the recipient of the information will not misuse the information, will not misappropriate the information, will not reverse engineer the information, will essentially not do anything with the information that is not specifically authorized by the disclosure in writing. Now, if there is a breach of that contractual clause, you anyway have an action as a breach of the confidentiality agreement. But in addition to that, you also have a separate cause of action, which is the breach of the duty of confidence. Okay. So whenever we are talking about infringement of IP, the infringement of IP can take three broad colors. It can be in the form of a violation of a statutory prohibition, like trademark infringement under Section 29. It could be a common law infringement, like passing off, right? Though not infringement, it is passing off. And there could be a third kind, which is a cause of action as a breach of contract. So IP infringement will probably be, if you can address IP infringement not just in one form, but you can address it across three principal forms, depending upon the facts in front of you. If there is a contract and there is a IP dealt with under that contract, then you could have a situation where you have all three available. But if it is not in the hands of a contracting party, but a complete stranger, like for example, a movie that is produced in Hollywood, the pirated CDs of which are being sold in Bangalore, then you're essentially looking at statutory frameworks and common law frameworks to undertake or address the issue of infringement. So the first question of whether it is infringement or not will be determined by referring to the statutory framework governing the IP, the common law framework governing the IP, and the contracting framework, if any, governing the IP. Now, upon examination of these three things, you will then know whether the infringement that you are dealing with is actually infringement or not, and what is the form and manner in which you can address it. Clear so far? Any questions? Now, the other thing to remember is that insofar as the governing law is concerned, especially when it comes to cross-border IP enforcement, there will be an impact that it will immediately have the moment it is because some jurisdiction may recognize IP that is registered in the US Patent Office. Okay. Now you realize that that US business method patent is being infringed in India. Now what you do is you come to India and you look at forms and manner of enforcing it. You will be immediately hit with two challenges. One, the patent itself lacks recognition under Indian law because it's a US patent limited to US borders. The second problem being that let's assume that you have applied for the patent protection in India as well. Indian law may come back and say, sorry, we don't recognize business method patents at all. Okay. Now, this is fairly straightforward if you're talking about a infringement action in the hands of strangers. Somebody in the US whose business method is being infringed by a stranger in India. But let us take, for example, a scenario where the business method is actually licensed to an Indian entity, right? Now, there could be situations, for example, that there is a particular form or manner of running a pharmacy store. Now, this business method is licensed to an Indian entity. Now, the Indian entity is breaching the terms of the business method patent license, and the US patent holder decides to enforce it. The first challenge is that India does not recognize business method patents, so patent enforcement as an action is not available. You can then perhaps look at, say, enforcing it as know-how or a trade secret or as copyright if you are able to establish certain literary work around it, right? So being able to determine the governing law's impact on the recognition of the IP will then calibrate what is infringement, what is not, and what remedies are available to you. If it is not infringement as per the law, then you will be in trouble, right? So a lot of times certain jurisdictions tend to say, we will not recognize unregistered IP. So civil code countries at one point of time would tell you that if you don't register your trademark, you can't expect it to be enforced in that particular country, right? But English common law is obviously very different. So depending upon where you are trying to enforce and what law will govern the enforcement, you will know whether something is infringement or something is not. And being able to make that preliminary assessment is very critical to understanding what is IP infringement and what is not. If it is purely within a domestic setting where the infringer and the victim are both in India, your job becomes very easy because you can always come back and say that, it is infringement because Indian law recognizes it. The problem is if it is cross-border in nature. Now, the other thing to remember is a lot of times your IP infringement could involve rights that concern in rem, or it could involve things like challenging the validity of the IP recognition itself. So, for example, in a trademark infringement claim, if the defendant says that I've never used the trademark, so I shouldn't be allowed to enforce it, he may want to challenge the validity of my registration itself, saying that it should be set aside on grounds of non-use. Now, these are things that can't be arbitrated in any forum except the forums recognized by law, either the courts of law or the specific administrative proceedings before the relevant registrar or the IP tribunals or the courts, right? Or the boards. Now, these are things what we refer to as litigations involving rights in rem. And those can only be litigated before a court of law or tribunals are officially recognized by the statute. It can't be litigated anywhere else. Similarly, certain forms of IP litigation, like for example, revocation of a patent already granted can only take place between patents or the registrar of trademark. Those instances, all the authority or the registrar that the statute officially recognizes. But if it is the case of IP rights or IP infringement coupled with or violation of confidentiality, confidential information, confidentiality agreements, then there are chances that you could have laws as well, and that arbitration to the concerned third party, those could also be capable of being arbitrated. But the difficulty is venturing beyond the contract for purposes of addressing or identifying infringement and enforcing it becomes very difficult. So to summarize, your governing law will define what IP right is recognized and what is not. So especially when it comes to cross-border IP, you need to be very cognizant of those risks. Two, depending upon the nature of the IP violation, it could either be a situation where you have to go to a court of law to litigate, or it could be an administrative action based on what the statute says. And if and only if it is coupled with some kind of a contractual framework, you could also look at addressing the infringement through means of the arbitration proceedings as well. Okay. Now, broadly speaking, when you've identified infringement and the IP, you have two broad categories of reliefs available to you. One is civil remedies, which could be a search and seizure order like an Anton Pillar order. It could be an order for preserving the evidence of infringement in the form of injunctions. It could be prohibitory injunctions restraining the infringer from infringing the IP. It could be to determine what is the profit made by the infringer and then asking for the rendition of those profits to the plaintiff. So to explain this differently, let's assume that my proprietary confidential information is stolen by the defendant. Now, I would have spent 3 years and $100 million to develop the trade secret. Because the defendant has managed to steal the trade secret, making the $100 million investment. But he is earning correspondingly, therefore, a significantly higher profit than what I am earning. In these circumstances, the courts will tend to take an account of how much profits they have unjustly made and then ask for those excessive profits to be transferred to me. So this is one of the common civil remedies in IP infringement, because quantification of losses from IP infringement is always a little challenging. Then there are damages also. So where you're able to establish that by stealing my IP or infringing my IP, this is the extent of commercial advantage that I have lost, which I would have earned if not for the infringement. So let's assume that today I am Ashok GV. I'm able to earn rupees XYZ every day because I render services at Ashok GV. Tomorrow, somebody else also starts practice misrepresenting themselves as Ashok GV, and that 5,000 or 10,000 or XYZ sum of money that I would earn gets diverted to them. In those circumstances, the money that I have lost because of the infringement can also be awarded to me as damages. Okay. This in itself could be a very long conversation about how damages are computed in IP law, especially in terms of when the losses that I've suffered are taken into account, when the profit that I could have made is taken into account to award the damages. But that's a very complicated exercise, which we will not go into too much detail today. The only thing to remember is that the law says if you are not able to ascertain the account of profits that the defendant has made, don't worry, you tell us what your losses are and we will look at compensating you. So civil remedies are broadly this in nature. Now, these are illustrative. They're examples. There could be a lot more. So for example, Indian law also looks at something called as a John Doe order, where if you don't know the details of the person infringing your IP, you can go and apply for a remedy against an unknown defendant and then enforce it against every single person that you come across who's infringing at a later date. So this is very common in large-scale counterfeit, product enforcement scenarios. Like, for example, a luxury fashion brand, which realizes that their perfumes are being infringed by n number of people in India. They can't identify each individual and wait. So what they do is they go to the court and get an order against an unknown defendant and straight away enforce the injunction. It could also be something called as a dynamic plus injunction, where especially in online piracy cases, today there is a website disseminating a cricket match without permission. That is stopped. Tomorrow it becomes a different website and starts again. So the courts have said you don't have to run back to the court every time. You can straight away, take the original injunction and enforce it against a new website as well. So this is called as a dynamic plus plus injunction. So remedies also keep evolving. These are illustrative civil remedies, not exhaustive. Now, when it comes to criminal law, the remedies are fairly set in stone because, as you all know, Article 20 of the Constitution is very clear. It is not a crime until the statute defines it as a crime, and you can't take a person's right to life and liberty away except through the procedure established by law. So keeping that in mind, criminal remedies are usually in the form of imprisonment, penalties, and fine. Right? So in these scenarios, typical remedy available to you is you employ the help of the police, conduct a raid on the premises of the infringer, seize the infringing articles, and then the state will prosecute the infringer for IP infringement. This is very popularly employed against pirates, movie pirates. So at one point of time, national market in Bangalore was not Hollywood films and Bollywood films. It was also a place in Hyderabad that was notorious for selling infringing copies of software, where you could obtain training in the most expensive software without paying as much money because it was a cracked version of the software being employed. Now, these are scenarios where your ownership over IP is not in dispute. You're not worried about whether the person is copying your IP or not because he's using my IP as it is. Therefore, I don't have to worry too much about establishing similarity of the IP, and then I straight away go to the criminal law mechanism. This has certain advantages, namely one, it has a deterrent effect, it is punitive, plus it inflicts the fear of the law in the infringer. The flip side or the difficulty of a criminal remedy is that I am not going to get anything at the end of it. The court may be generous to award some compensation based on the fine that it levies on the accused, but there's no guarantee that my losses at actuals will be compensated. With civil remedies, there is a greater certainty that if I'm able to prove my losses, there is a good chance that losses I've suffered at actuals, I will receive compensation. So based on the nature of the infringement, what you expect to get out of it, whether the idea is to make an example, punish somebody, or to essentially address your own losses, people will decide whether civil remedies or criminal remedies are invoked for infringement. Now, this is where it becomes very critical because every enforcement action has three components: identification of a right and therefore identification of the infringement of that right. That's point number one. Point number two is the procedure for enforcing the right. And three, what is the remedy for the violation of the right? Now, we dealt with the identification of the right. We dealt with the infringement of the right identified. The second step, which is very important, is the procedure. Because though you might have a right, if the form and manner of enforcing that right is not compliant with the procedures of law, you could get into a lot of trouble, though you have a perfectly good right. Now, so two things that you need to be very particular about, and no infringement action can be addressed, whether you are the plaintiff or whether you're the defendant, whether you're appearing for the alleged infringer or the victim. You cannot do justice to the mandate that you have unless and until you know two things: the Code of Civil Procedure and the Bharatiya Nyaya Suraksha Sanhita. Please excuse my pronunciation if I'm not getting it right. As a South Indian, the name is a little challenging. Now, these two laws are very critical because though you might have a very nice Trademarks Act, you could have a very nice Patents Act, you could have a very nice Copyright Act, how you choose to enforce and where you choose to enforce will be dependent on these laws. State-specific procedural laws, which has letters patent jurisdiction, like Delhi or Bombay, will also have something called as the original side rules, which will determine how the IP enforcement complaints are to be filed, the procedures for it, all of it. So being able to be very aware of these procedural laws is very critical. Otherwise, you can't address the issue of enforcing the IP that you have and addressing the issue of infringement. Now, CPC especially is one of the most misunderstood and unfairly targeted laws in the country. People keep accusing it of being draconian, not catching up with the times, being very primitive in its thinking. But if you think about how under the guise of just Section 151 CPC, the very court which evolved the Anton Pillar test several decades back is able to also evolve the test for dynamic plus plus injunctions, for John Doe orders, there is remarkable judicial innovation that's come out of the Code of Civil Procedure. And sometimes the litigating lawyer is not distinguished by his knowledge of IP, but is distinguished by his knowledge of the procedural laws. So I can't stress on the importance of knowing these two laws enough. Whether you choose civil or whether you choose criminal, one of these two laws will be relevant. If you choose both these laws are relevant. Because in law, you can do both civil and criminal simultaneously. No prohibition saying if you choose civil, you can't do criminal, or if you do criminal, you can't do civil. All remedies can be simultaneously and parallelly invoked. Absolutely no bar against it. But the effectiveness will depend on procedural compliances that are in front of you. Now, the other challenge also is gathering evidence of infringement, because infringement sometimes doesn't happen in the location convenient to the plaintiff. So we had a situation, for example, where a client's products in Bangalore, a very well-known product, was being infringed by an infringer in a very remote part of one of the less stable law and order frameworks in the country. Now, we got an order saying that it's a John Doe order restraining unknown defendants, including the named defendant from that region of India where this infringement was taking place. The order said you can't infringe anymore, right? And it also gave me permission to go ahead and apply for search and seizure if required. The problem is that wherever we were looking to litigate, we would ultimately need the assistance of the police to enforce the order of the civil court. That institutional mechanism make matters worse. We were very clearly told that because of the law and order situation there and a certain counterinsurgency operation that was taking place and the presence of insurgents, the infringers potentially had backing from some of these insurgents. So the raid might have serious security implications for the advocate commissioner who was appointed. Right? So IP infringement action by its very nature involves different geographies where the dynamics could be very different. So sometimes being able to gather evidence itself is very tough. And that's where the role of investigators becomes very important. Today, there are a lot of these detective agencies, such as the Eagle Eye Detective Agency, which could essentially assist with gathering evidence of infringement so that you have the data beforehand before you start your litigation. It could be a slightly less contentious approach. One of the best examples is sample purchases. So if I come across a counterfeit product on Amazon, how do I establish that there is infringement taking place? I set up somebody to go buy the infringing product, collect an invoice. The product and the invoice becomes my evidence to show that infringing products are being sold. This could also be in the form of trap orders, where your investigator will essentially go make a few fake purchases. And therefore, that trap order, which is to trap the person into selling an infringing product, becomes your basis. It could also be on the basis of advertising and marketing records. One of the best examples I can think of is how many of you have received a call for water purifying maintenance services randomly? People calling and saying that they can come and service your water purifier. Saidi Pelamati, ever received such a call saying that we are so and so people? We will come and address the maintenance of your Eureka Forbes water purifier or some other brand. So essentially, one of the very popular forms of infringement is in the nature of these maintenance services being provided by falsely representing themselves to be associated with the parent brand. Now, the quality of the maintenance is suspect, the quality of the spare parts and the accessories is suspect, but these are very challenging in terms of being allowed to continue, because tomorrow, if somebody drinks that water, they could fall ill. Right? Today, we have an emerging threat in Kerala where to be able to identify whether there is infringement or not and what is the extent of infringement. Now, you have the evidence. You have figured out whether you want to do civil or criminal, enforcement action against infringement. Now, what are the considerations for you to choose the forum? Okay. Now, the first thing is don't forum shop. One of the recent instances where there were examples of forum shopping was involved in the Madras High Court involving PhonePe, where the court eventually found that the plaintiff was engaging in some form of forum shopping, where they were going from one forum to the other. I go to one forum, I don't succeed, I withdraw, I go to the next forum and I re-agitate the same issue. Right? Now, that is something that the law condemns. Right? So if you're going to initiate litigation, you might have options to initiate litigations in multiple locations. You could, for example, initiate one litigation for IP infringement taking place today And 1 week from now, if there is a different infringement taking place, a third infringing product or a second infringement product being sold, that gives you a separate cause of action to file a separate suit. Right? So, or today there is a sale of an infringing product in Bangalore, I institute a suit in Bangalore. Tomorrow there is an infringement or a sale of an infringing product in Delhi. Against the same defendant, I file the suit in Delhi. Now, these are things that the law doesn't take very kindly to. So don't engage in forum shopping. Very important. The second step is when you have to choose which forum, you have to first ask yourself which court has jurisdiction as per law or which authority has jurisdiction as per law. Because all the creativity in the world is useless if the law itself says that this court does not have jurisdiction. In the context of trademark and copyright, there were these famous case laws involving IPRs versus Sanjay Dalia and a whole bunch of follow-up case laws, which essentially read down the provisions of Section 134 of the Trademarks Act, corresponding provisions under the Copyright Act, and then held that though the law might tell you that wherever you have a business, you can litigate as the plaintiff, but not only will your convenience be considered, but the inconvenience caused to the defendant will also be considered. And a forum that balances the interests of both parties will have exclusive jurisdiction. So the court said that if Ashok has an office in Bangalore and Delhi, main office Bangalore, satellite office in Delhi, the cause of action is also here in Bangalore. Though the law says I can institute in Delhi because of having my subordinate office there, I still have to necessarily bring it in Bangalore because my main office is here. The infringement is taking place in Bangalore, and perhaps the defendant also is in Bangalore. So the law will tell you where you can go, and sometimes you can't cross those boundaries. Within the available options as per the law, you also have to ask yourself how IP sensitive or how IP aware the jurisdiction is. Certain jurisdictions have better IP awareness compared to others. And a lot of times, if you have options available between an IP sensitive or aware jurisdiction and an IP not so aware jurisdiction, you would want to choose the jurisdiction better known for IP enforcement. Next, budget for enforcement, because enforcement action can be expensive. Investigators cost a lot of money. So depending upon what your budget is, you may want to say, okay, if I have a lot of budget, civil forum. If you don't have a lot of budgets, I file a criminal complaint and forget because the state will then take over. All of this is determined by the objective of whether you want civil remedies or criminal remedies and whether you want compensatory relief, that is to put you in the same position that you were in if the infringement had not taken place, or is the effort to punish the person. If the idea is compensatory, it is civil. If the idea is punitive, it is criminal. If the idea is compensatory and punitive, you do both. Now, the next step, of course, is to also file your complaint or the plaint, depending upon it is civil or criminal. Now, one thing to keep in mind is, depending upon it, whether it is a civil or a criminal action, the nature of the remedy you seek for will also influence the nature of the draft. Civil pleadings are necessarily a little detailed, a little heavy on the number of pages because you have to go into a lot of details. Complaints, especially to the police, tend to be very brief, all of being a judge. Now, whether you go to criminal or civil is also determined by other factors. What is the nature of the infringement? Let's assume, for example, that I am the maker of the South Korean film, The Man from Nowhere. Tomorrow, I get to know that Bollywood is making a movie called Rocky Handsome. And I think that the Rocky Handsome movie is a direct infringement of the South Korean movie. Here, there is a lot of adjudication involved because the judge will have to essentially take a look at both movies, determine similarity, and then figure out whether infringement or not. This is something that I would much rather take before a civil court than before a criminal court. Okay, because civil courts are better equipped, and the police certainly does not have the wherewithal to determine if Rocky Handsome is similar to The Man from Nowhere. On the other hand, if the complaint is of piracy, the movie is mine. The Man from Nowhere is being sold through a distributor in India. But other than the distributor, there are people sitting in national market in Bangalore who are making pirated versions and selling it. Now here, there is no need to adjudicate whether there's infringement or not, because it's my IP, the movie is Man from Nowhere, and somebody is selling it without my permission. This is a case where I would much rather take it to the police than before the civil court, because it's easy for the police to get involved without them having to apply their mind to determine whether it is infringement or not. So the nature of the infringement also influences whether you go before a civil or a criminal forum. lot of adjudication, lot of research, complicated questions of law. Civil forums are better, easy to determine infringement, very easy to identify who's at wrong and whether it is IP violation or not. Go to the criminal court. Right? Now, what should you write in your complaint or plaint? Right? So complaints are still okay because you only have to give information, not detailed pleadings. So even a one-page complaint will be more than sufficient to set the criminal law machinery into motion. But civil law will require you to set out ingredients for each version of IP. If it is trademark, you'll have to establish that the trademark belongs to you. It is not generic. It has acquired secondary meaning in your name. Plus, above and beyond that, the defendant is infringing by doing ABCD things. But if it is trade secret, the law will require you to establish what is the trade secret, how much money has been spent developing the trade secret, how many people within the organization know it, how many people outside the organization know it, what technical and legal measures have you employed to keep the trade secret confidential. You have to set out all of this in your plaint. Right? So each IP will require you to approach the drafting of the plaint differently. Now, to determine what should go into it, you have to consult case laws and refer to procedural laws. So the relevant procedural laws as an illustration only is Order 6 and 7 and 8 of the Code of Civil Procedure, which deals with pleadings generally, plaint and written statement. And now, of course, with the Commercial Courts Act, there's a lot of changes as to what else should go into the plaint as well when it comes to a commercial dispute. So you need to go through all of this to determine what you should write and how to write what you write in the complaint or the plaint. Now, it's also important to understand and recognize potential defenses, right? So, for example, one of my favorite topics in IP law is, especially in the context of trademarks, is something called as descriptive fair use. Now, this was famously adjudicated by the US courts in the case of Oprah magazine, where the defense pleaded was that of saying, I'm not infringing the IP, I'm not using it as a trademark. I am, in fact, describing the trademark itself of the plaintiff, right? So this was a scenario where they were trying to argue that only if I sell the trademarked article or the service, then there could be infringement. But if I'm merely referring to the trademark in my product, then it need not be infringement. The other example is of nominative use of a trademark. So let's assume, for example, that you have a Toyota car. I established a service station called Ashok Service Station where I mentioned that I'm servicing Toyota vehicles. This need not necessarily be infringement of the trademark because it's nominative use. So these are some very important defenses to keep in mind, because while you're drafting your complaint or your plaint, you may want to preempt this. By example, for going into the example of why the use of the trademark by the defendant is neither nominative nor descriptive fair use, for the reason that the usage is in the nature of the usage of a trademark. So when you're able to anticipate the defenses, you could also look at preempting it. Similarly, acquiescence essentially requires you to have knowledge of the infringement and to have actively encouraged the infringement to continue. You could then have, if you have to address it as a plaintiff, you will then plead that, hey, I was not aware of the infringement until very recently. Therefore, tomorrow when they come back and take the defense of acquiescence, saying that you knew about the infringement, you actively encouraged me by keeping quiet, now you can't come back and stop me. Your plaint already has the relevant counter to that by saying that, look, I got to know only in 2024. You may have been infringing for the last 20 years. So the requirement of prior knowledge of acquiescence is essentially taken care of, right? Similarly, there could be defenses of trademark abandonment on the part of the plaintiff. One of the best examples is a case law involving Burger King, where the defendant, who was also trying to use a similar trademark, came back and said, Burger King is great in the US, but they haven't used the registered trademark in India. So then the court took note of the pleadings of Burger King, which disclosed that in anticipation of their entry in India, they had done a lot of pre-market entry work, like marketing, advertising, so on and so forth. So the court came back and said that, look, the plaint very clearly shows that they've taken steps for pre-launch of the brand, which is sufficient use. So therefore, they said the issue of whether or not Burger King has abandoned the trademark will not be material anymore. Burger King has been clearly using the trademark. So a lot of times anticipating the defenses is also important. There could be issues regarding jurisdiction. So one of the defendants may come back and say that the courts in Bangalore may not have jurisdiction. So if you plead correctly that the infringement took place in Bangalore, that the nature of the most of our infringement took place across the country, but the majority of it was in Bangalore. Those are some things which could automatically address the issue of jurisdiction. Similarly, pleading the date of knowledge of the infringement, when you got to know of the infringement, could help address issues of limitation, delay, and latches. So very, very important to be able to think as a defendant and figure out what all they might come back as a defense and try and preempt that in your plaint when you draft your pleadings for IP infringement. Now, in IP infringement cases, it's all one thing that is also very critical is the role of interim relief. We talked about anti-pillar orders, Mara injunctions. Now, whenever the IP litigation is lodged, more often than not, at the stage of interim relief itself, I've seen that extensively with the Delhi High Court, where once the ad interim ex parte injunction is granted and the injunction thereafter comes out in the form of a confirmed injunction, the defendant enters appearance, and once the just give me 1 second, please. Sorry. So the injunction, ad interim ex parte injunction is granted before the defendant enters appearance. Defendant enters appearance, contests the injunction. The court still feels that there is infringement. The injunction must continue. You see a lot of judgments where they say there's nothing else that is necessary to be looked into, and straight away the suit is decreed. So the way you approach interim relief can essentially ensure that one, the entire suit comes to an end, especially if it's a civil proceeding. Two, your interim relief can either disarm the defendant and incentivize an early settlement, or it could aggravate them and force them to, or infuriate them enough to make them contest it. So one of the best examples where infringement actions backfired was a series of software piracy cases where despite being in Kanyakumari, the litigation was lodged in Delhi. The fact that the plaintiff's place of business is there. Now, these kind of litigations eventually led the Delhi High Court and the Supreme come back and say, sorry, just because you have your office in Delhi doesn't mean litigate here. You can't drag a defendant on Kanyakumari all the way here, litigate at the right place and ensure that it is fair to both parties. So you don't want the situation to aggravate, so you need to really choose interim release very carefully. Right? Done right, the lengthy litigation that we often fear can be cut short only because of the fact that you got your ID right. Interim relief, plaintiff more or less has won. Interim relief refused, the defendant has essentially gained a significant advantage. The reason being the litigation will now anywhere run its course, and during that entire time, he or she is free to do what they want at the risk of later having to pay damages. Now, last but not the least, the scope of trial is very important. Okay, so whenever you have these infringement cases come up before court, once the pleadings are completed, the plaintiff is filed and the written statement is also filed, the court will identify what allegations are made by the plaintiff which are denied by the defendant. And those areas of disconnect between the plaintiff and the defendant are translated into issues. And both parties are essentially notified as to whether or not they should who should prove what in the scope of the proceeding. Now, at this juncture, it's important as the litigant that you take stock of what the issues are and determine if something needs rectification, right? So based on that, your entire trial could essentially go through a very different life cycle. Now, this second thing also, sorry, I think there's an internet connection issue. Give me 1 second, please. So once you have identified the issues, chances are that you as the owner of the IP will be required to prove the existence of the right. Like we discussed in the case of trade secrets, merely saying that you have an agreement is not sufficient. You have to prove that you have taken steps to protect it. You have to prove that you have taken sufficient expenses to bring the trade secret into existence. You have to prove that you have taken sufficient steps to minimize the number of people within and outside the organization that know it. So you will have to identify all that the law requires you to establish that right and prove that in the course of the trial by providing relevant evidence. Especially with the advent of the Commercial Courts Act, you have to remember that if you haven't produced all the documents in support of your case at the stage of filing the plaint, or at a maximum leeway of 30 days in the case of urgent filings, you may thereafter not be able to produce any additional document unless you are able to establish with probable cause that you did not have these documents available to you earlier to provide it. So being able to plan your evidence ahead of time and then filing your case is very, very important. The third thing that you look at establishing in the trial is bad faith on the part of the defendant. You want to establish that the infringement is not only taking place, it is driven by malice. Then you will have to prove the quantification of the loss or the harm, that whole thing that we discussed. about how much profit the defendant has made or how much losses you have sustained. That is something that you'll have to prove in the course of the trial. Last but not the least, the purpose of the trial is to advance the credibility of your own witnesses and discredit the credibility of the witnesses appearing for the rival party. Okay? How you do that is through cross-examination. Now, what kind of evidence are typically employed in IP infringement cases? Now, let's assume, for example, it is trademark infringement. Consumer surveys are an example to show that when the survey was done, defendants' products were found to be confusing by 80 or 90% of the sample population. One of the easiest ways of proving that there is confusion caused by the defendant's use of the infringing trademark. Sales records that you have, the marketing and advertising expenses that you have incurred, a certificate from the chartered accountant evidencing how much money has gone into the trademark or the trade secret or the copyright. What are the sales that were being undertaken before the infringement began? What sales dropped after the infringement began? All of those are essentially evidences to prove infringement and to help quantify the amount of loss. Then evidence of defendant's conduct. Right? Did the defendant undertake a trademark search before adopting the trademark in question? Did they undertake a patent search before using a patented product? If they did, it shows diligence, and therefore they could still come back and say, sorry, I was not aware despite doing the due diligence. But if they did not undertake this exercise, straight away went ahead and registered the competing IP or tried to use the IP, then there could be evidence of malified intent or bad faith conduct on the part of the defendant that could enhance the remedy available to you and also invite them for punitive consequences. Same thing for the accounts. You'll have to establish based on the accounts of the defendant by summoning those accounts in the court of the proceedings to essentially establish that this is the extent of unfair profits made by the defendant. If you're able to establish all of this, then essentially you have more or less come to the point where you have ideally and conclusively established the existence of IP infringement. So then the court will obviously look into the proof you have provided for your losses and then determine how much money you need to get. Right? So this brings the whole journey of an IP infringement action from the identification of the IP, identification of the infringement, procedures for enforcing the IP that is being infringed, what is the evidence and the scope of trial in IP infringement cases, and the final remedy, which is damages, accounts, prohibitory injunctions, Anton Pillar, Mareva, etc., etc. Right? So we come to the conclusion of the session today. One, always remember that IP is not just the product of law. A lot of people assume that the registered IP and their whole effort to enforce it comes to an end. A lot of people assume that if you have a good NDA or a confidentiality agreement, your confidential information is completely safe. Nothing could be further from the truth. It's IP registration or contracts are the starting point. Effective IP management, employing good practices, evidence of those good practices being put in place, like trade secret policies, trademark usage guidelines, right? To show, for example, a lot of you would have heard about the generic mark, Xerox being a generic mark. Now, if you have brand use guidelines, which will define exactly how the brand is supposed to be used, right? Whether as an adjective, whether as a noun, that will then show that you have taken sufficient measures to ensure that your trademark does not become generic, that it continues to be distinctive. That will enhance the availability of good protection at the hands of a court. So being able to document these good practices like trade secret policies, trademark usage guidelines, a patent notice on your product saying this product is essentially the subject matter of patent application bearing number so-and-so. These are good practices that enhances the availability of protection for your IP. Now, IP enforcement is also a matter of strategy. Like we discussed, whether it is a in rem litigation, in personam litigation, whether you want to initiate civil or criminal, whether you want to litigate in Bangalore or Delhi, everything needs to be carefully thought of, right? If there is no sufficient thought into it, then it becomes very difficult, right? So third, civil and criminal, both options are available. Each have their pros and cons. That's something that you have to essentially determine and take a call. Last but not the least, you need to prepare and you need to innovate. Never assume that there's 100 years worth of jurisprudence and you can safely do what you want. There is always scope to improvise, to make modifications, to innovate and come back with better solutions for IP infringement. Be agile and adaptable. You should be in a position to quickly deploy across a range of jurisdictions, either civil or criminal. I keep telling businesses that don't wait for infringement to go and make contact with the police. Build a relationship with the police. Start doing trainings with the local police. Sponsor a few training programs for them, right? Generally invite them for regular, town hall meetings where you as a business owner goes and discusses with them what issues you're facing, right? Keep that relationship alive throughout the year so that when there is infringement, it's easy for you to deploy the help of the police. But if you go at the nth moment, you're a stranger, there are murder cases, there are a whole bunch of other more serious proceedings. IP infringement may not get the level of importance it needs. And being able to understand the police bureaucracy is also very important. A lot of times you may not want to go to the local inspector. You may want to start with the commissioner of police or the deputy commissioner of police or the assistant commissioner of police. Go with a complaint there first, have them direct the inspector before going to the inspector, because there will be better awareness at the ACP level than at the level of the inspector. Last but not the least, when it comes to choosing the forum, remember, you have to essentially ensure that you fight fair, but there's no duty to engage in a fair fight. There's a big difference. Right? So when you choose your forum, you can be strategic, but not go beyond the confines of what the law permits. That brings us to the end of the session. If there is any questions or queries, I'm happy to take them now.
Yes, any questions? Elamati or Saidi? I think this 1 hour covered a lot of important aspects, right? From understanding infringement to the remedial measures. I mean, this was a lot that was offered, I think, in just 1 hour. Thank you, Ashok. This was very well justified, I think, in just an hour's time. Yes, Saidi, if you have a question.
A very excellent session, ma'am.
Yes, indeed.
Though it's a 1 hour session, sir has explained in a very excellent manner.
That's right. Yes. Very comprehensive, actually.
Yeah.
So just a word of caution, we discussed the broad concepts. Make sure you open the relevant statute, Trademarks Act, Patents Act, and then see how these concepts are expressed in those statutes, right? Because like we discussed, we have understood the broad science of IP infringement, but how it relates to each subject is something that the statute will have to educate you. So because of the 1 hour, we had to crunch in a lot, but make sure you do your homework.
Yeah, and I think this video lecture would be sort of a ready reckoner for any practitioner on IP litigation. So you can very quickly go to certain points and you can capture them very easily. So that was, I think, the best part of this session. Thank you so much, Ashok. Thanks for your Saturday evening, and we look forward to more sessions later in the upcoming sessions, or maybe the courses, because we are sort of closing this session. So it's been a 6-month program, and thanks for all your cooperation and your commitment to the EBC learning. And
My pleasure.
so this course will perhaps end around second week of October, and one more session next week, and then we will be closing for an exam and henceforth. So thank you so much, and have a wonderful weekend. Thank you, everybody, and thank you, Saideep. We'll connect in the next session. That's on next Saturday, 27th, I guess. Yeah. Okay. So thank you.